to our next session. As previously mentioned, I am one of the research professors here at the University in the Stegner Center, and I am just so thrilled to introduce our next speaker. Many of you know Ann Castle as a former Assistant Secretary for Water and Science at the Interior during the Obama administration. You may know her in her current role as a senior fellow at Getch's Wilkinson Center at Colorado Law. Her credentials and accomplishments are extensive. I encourage you to read the full bios that are available for all of our speakers that are online. We couldn't have a better person here today. I really got the pleasure of getting to know Ann quite well over the past year and a half on the Water and Tribes Initiative, Universal Access to Clean Water Project. Again, her knowledge, her analytical thinking, her leadership skills. She is someone that you want advocating on your behalf. And we could not have accomplished nearly as much as we did without Ann's involvement. So I'm thrilled to have Ann Castle come up and talk about the law of the river, how it's evolved over the past 100 years, and adapting or not adapting to the social, economic, and environmental and political changes. As a reminder, we are collecting audience questions on Slido. Those are being recorded. So even when we run short on time to address them immediately after a session, we will be able to incorporate them later on throughout the conference. So with that, let's welcome Ann. Thank you. Yeah.
Well, good morning again, everyone. Great to be here. So it's my job over the next 30 minutes to give you 100 years of the law of the river, that storied set of agreements and treaties and federal statutes and records of decision and everything else that makes up the law of the river. So it's going to be a whirlwind tour. And I'm trying to set your expectations here. But we're going to hit the highlights, and I'm going to spend most of the time on the 21st century developments. So first, just some context about the law of the river. People have mentioned some of these things, but I think it's important to set the stage. This river serves 40 million people in 2 countries. 7 US states, 2 Mexican states. And in the US, of those 7 states, 4 of them are in the top 8 fastest growing states, including, of course, Utah, where we are. 5 million acres are irrigated, some of the most productive agricultural land in North America. There are 30 Indian tribes in the basin. There are 11 national parks, and it supports a huge segment of the US economy. These figures are kind of old. They're like 2013 figures, $1.4 trillion in the economy. That could be double by now. And a significant portion of that is the recreational industry. And that's important to think about as we think about the values in connection with operational decisions that we're making in the law of the river. So just a little gloss on some of the compact facts that Larry just presented in such an amazing and comprehensive way. We frequently hear that the Colorado River is divided equally between the upper basin and the lower basin, but of course, that's not the full story. We know that the upper basin and lower basin both got 7.5 million acre feet, except the lower basin got an additional 1. And then there's that very significant condition on the upper basin's allocation, the 75 million over 10 obligation at Lee Ferry. And then we also know that deliveries to Mexico, if reached in the future, were to be split equally between the upper and lower basins. Sometimes when there wasn't a surplus, but what does a surplus mean? And do we have one now? So there, as Larry said, there are a lot of unresolved questions and much more complexity than you frequently read in the newspaper about characterizations of the compact. So starting with the next steps, Larry mentioned that the 1928 Boulder Canyon Project Act approved the compact, but it also authorized the lower basin states to enter into an interstate allocation of their 7.5 million. It authorized them to enter into a compact. That never took place, but these amounts, 4.4 million acre feet for California, 2.8 for Arizona, 0.3 for Nevada, those were authorized in the Boulder Canyon Project Act. And then in 1944, of course, we did reach a treaty with Mexico that provided for 1.5 million acre feet to be delivered at the border every year. There was a provision for a reduction of that amount in the case of extraordinary drought, which was not defined. And that, as Larry said, has been a source of controversy. Then in 1948, we have the Upper Basin Compact among the 4 Upper Basin states and the Department of the Interior. And that did constitute an agreement to allocate the Upper Basin's portion of the river among those 4 states. And you can see those allocations here, but they're not volumetric. And the reason is because the Upper Basin's allocation is conditioned on that 75 million over 10 requirement in the compact. So the Upper Basin's allocation isn't fixed in volume, but can vary depending on what the river produces. And so the allocations to the Upper Basin states in the 1948 compact were percentages, with Colorado getting the lion's share, a little over 50%. And you can see the other percentages here. The Upper Basin Compact also established the Upper Colorado River Commission, the UCRC. And that is a governing commission for ensuring that Upper Basin obligations are met, obligations under the compact. It has 1 commissioner from each state, and we have several of those commissioners in the audience, and the new executive director, Chuck Cullum of the UCRC. There's a federal commissioner. That position is vacant. It has been vacant for some time. And it authorized, the compact authorized the UCRC to determine the extent of curtailment that might be required in each of those Upper Basin states. So it contemplated that curtailment could be required in order for the Upper Basin to meet its obligations to the downstream states. It also has this, what's been called a penalty box provision, which says that if curtailment is necessary, and if there's a state in the Upper Basin that has used more than its percentage share, those percentage allocations on the previous slide, then that state will be the first to be curtailed to the extent of whatever the increment over the percentage was. And then it goes back to everybody else. That's a problematic provision because in any river operation, you're going to have some states using more than their percentage, some states less. Hopefully it balances out over time, but the curtailment provision sort of puts the hammer down and forces any state that has perfectly legally overused or used more than its percentage allocation to then pay that back first. Then we come to the first big court decision that constitutes part of the law of the river, Arizona versus California. Arizona brought a lawsuit in 1952 against California, and because it's a state against state lawsuit, there's original jurisdiction in the United States Supreme Court. And Arizona requested interpretation of certain provisions in the Colorado River Compact. Who gets that 1 million extra acre feet that is allocated to the lower basin? What's that mean? And what does beneficial consumptive use mean? That's what's allocated by the Colorado River Compact. And then how do we account for evaporation? In 1952, Hoover Dam had been constructed, Lake Mead is there, evaporating water off of its surface. How do we account for that? So the Supreme Court decision that we ultimately got 11 years later in Arizona versus California answered none of those questions. So 1963, we have, and this sort of demonstrates the inadvisability of asking Harvard-trained lawyers who have no idea about water law to make decisions about it. So that's an editorial remark. So the Arizona versus California decision, even though the complaint by Arizona had originally asked for interpretation of the compact, it did not interpret the compact. It interpreted the Boulder Canyon Project Act, and it interpreted it to affirm those allocations among the lower basin states that were authorized by the Boulder Canyon Project Act. So 4.4 to California, 2.8 to Arizona, 0.3 to Nevada. That was affirmed in the Arizona versus California decision, and to be implemented through contracts with the Secretary of the Interior. It also decided that the Boulder Canyon Project Act dealt only with mainstream Colorado River water. So water in the main stem, what we call the main stem today, not in the tributaries. So those numbers, the 7.5, 4.4, 2.8, that is main stem water and doesn't count the water from the tributaries. Now that is the Supreme Court's interpretation of the Boulder Canyon Project Act. We don't have an interpretation of the Colorado River Compact. And the Colorado River Compact was pretty clear that it was allocating all the water in the Colorado River system, including specifically the tributaries. So again, Larry alluded to this. This is a continuing source of controversy. So fast forwarding through about half a century, we have federal statutes in 1956 and 1968 that authorized federal water projects that were designed to allow the states to develop their allocations in the Colorado River Compact. So the 1956 Act authorized Glen Canyon Dam, Flaming Gorge, the Blue Mesa Project, whole slew of other projects. The 1968 Act authorized the Central Arizona Project that as we heard, was a gleam in the eye of Commissioner Norviel back in the 1920s. And the 1968 Act also directed the Secretary of the Interior to develop operating criteria for the two big reservoirs. Lake Powell had just been constructed in the 60s. And there was a need to coordinate the operations. And the Secretary did that in 1970 with the Long Range Operating Criteria, or the LROC. So fast forward again to the 21st century, and you all read the papers. I mean, we have been in a very, very dry period for 22 years, ever since the year 2000. Some people refer to it as a drought. Other people don't like that word because it implies that it's aberrational and might change back. We're looking at climate change impacted flows in the Colorado River system, and things are not great. So this is just a couple of headlines, including the one in the top right about a recent study came out last month, finding, based on tree ring records, that the drought that we're experiencing in the 21st century is the worst in 1,200 years. And that obviously has ripple effects through the whole system. The graphs on the bottom just show Lake Mead and Lake Powell levels, and you can see there's a trend there. So there have been considerable efforts to address that problem in the 21st century. interim guidelines, agreements with Mexico, the drought contingency plans, and most recently, the 500+ plan. And I'll talk about each of those. So first with the 2007 guidelines, these are operational guidelines promulgated by the Secretary of the Interior with considerable input from water using interests throughout the basin, and most particularly based on an alternative proposed by the 7 basin states. They provide for sharing of shortage and surplus. Unfortunately, we've never really gotten to use the surplus sharing provisions, but the shortage sharing provisions are in effect and are being built on. They also, the 2007 guidelines also provided for the very first time for banking of unused water in the lower basin. Previous to these guidelines, if a lower basin state didn't take its full allocation, it went to the next user in line, creating no incentive for conservation and no way to store up water for a drier period. But the 2007 guidelines changed that with a program called Intentionally Created Surplus. And that program remains in effect today. It allows the states to actively conserve water that would have otherwise been used, bank it in Lake Mead, and draw it out under certain conditions. The guidelines provided for balancing the contents of Lake Powell and Lake Mead. That's something that is called for in that 1968 Basin Project Act. But the 2007 guidelines have a lot of detail about exactly how that balancing is going to occur. And then they are effective through the end of 2025. So here is the chart that you most often see associated with the 2007 guidelines. This is a chart that tells us how deliveries to the lower basin states will be reduced under certain circumstances based on Lake Mead levels. So in the left-hand column, you have Lake Mead elevations, and these are elevations above sea level. And just for context, Lake Mead is full at around 1210 feet of elevation, empty around 850. And so these tiers that you see, starting with 1075 to 1050, those are pretty low elevations in Lake Mead, representing like 25 to 40% of capacity. And then you can see if you go across the columns for Arizona and Nevada show the reductions in the amount of water that will be delivered to those states when Lake Mead is reaching those levels. So first question always is, why are there zeros in the California column? And that's because of a provision in that 1968 Basin Project Act that subordinated the Central Arizona Project to California's 4.4 million acre foot allocation. And there's a storied history there. I won't go into all of it, but subordination means that if there's shortage, then the subordinated allocation loses first. And the Central Arizona Project takes about 1.5 million acre feet a year on average. And so California's position in connection with the 2007 guidelines was, no, we don't need to reduce our deliveries until the Central Arizona Project has been shorted. And so that's why you see the zeros. That position has been modified, and we'll go into that. Then we start the agreements with Mexico, Minute 319 and Minute 323. The first one was signed in 2012, was effective for 5 years. It's a really historic binational agreement. And it was, and its successors have been pointed to in binational river basins all over the world as an example of international coordination. It provided for Mexico to experience shortages based on those same Lake Mead levels, which is It's a pretty amazing accomplishment, and it also serves to define that undefined term of extraordinary drought from the 1944 treaty. So it addressed shortage sharing, it addressed binational environmental projects, it allowed Mexico to store unused water from its allocation in US reservoirs, because there aren't big storage reservoirs in the Colorado River Basin in Mexico. That was also historic. And you may remember there was a pulse flow into the Colorado River Delta in 2014. That was as a result of Minute 319. You probably recognize some of the people in the picture. That handsome guy in the front left is Roberto Salmon. Where are you, Commissioner? There he is in the back. Roberto was the Mexican commissioner to the International Boundary and Water Commission at the time, and until very recently. Ken Salazar, Mulroy, Mike Connor, Bart Fisher, probably a lot of you are seeing familiar faces. That was followed by Minute 323, which was the renewal. Basically, after the expiration of Minute 319, it was signed in 2017. It provided for even deeper cuts to the Mexican deliveries. It was conditioned on the US states reaching their drought contingency plan, which hadn't happened as of 2017, but was anticipated. And that is effective through 2026. Then we come to the drought contingency plans. This was based on a recognition starting back in 2013, 2014, that the 2007 guidelines weren't enough to slow the slide of the reservoirs and deal with the imbalance in the system between supply and demand. And so it was recognized that additional actions were necessary in order to keep the two big reservoirs from reaching those critical levels. There are different components of the drought contingency plan for the upper basin and the lower basin. For the lower basin, there is a new shortage sharing schedule building on the schedule from the 2007 guidelines. And there's more flexibility in that intentionally created surplus program, allowing more incentive for conservation in the lower basin states and storing that water in Lake Mead. And the lower basin DCP is effective through 2026. This is what it did to the shortage sharing provisions of the 2007 guidelines. These are all of those reductions and contributions to Lake Mead added together. And what's highlighted is new stuff. So you can see that on the top row, the reductions start at a higher elevation in Lake Mead, at elevation 1090 instead of elevation 1075. And then also on the left there, you can see there are multiple gradations in the elevations between 1050 and 1025. And both of those provisions are intended to sort of get after the problem sooner and be more proactive to really try to stave off Lake Mead getting down to a critical elevation like 1025 or 1020. You can also see in the second column that California is in the game. That there are now reductions to California's allocations from the river at those lower elevations in Lake Mead. We've got a new column for the Bureau of Reclamation, USBR. The secretary committed to find or pay for conserved water, system water, in the amount of 100,000 acre feet every year. You've got Mexico's reductions now. So a lot more complexity in the shortage sharing schedule after the DCP agreements. But this isn't even the full manifestation of the complexity. This is. because there are different rules applicable to the 2007 reductions than hold for the DCP contributions to Lake Mead. So this chart shows those differences. So there's two different columns for Arizona, and two for California, two for Nevada, two for Mexico. So you can see all the differences, but the bottom line is at the lowest elevation for which we've provided in Lake Mead, we have reductions in deliveries of 1.475 million acre feet. So call it 1.5 million. And this is where we are today. Lake Mead is at elevation 1064. So we are in this tier 1 of delivery reductions. So there are reductions across the board to deliveries this year. The Upper Basin DCP has basically 3 prongs. One of them is continued weather modification or cloud seeding. That's been going on for a long time and is continuing. There is also an agreement for drought response operation of Upper Basin reservoirs and for investigation of a demand management program. And I'll talk about both of those in a little more detail. All of the Upper Basin DCP agreements are effective through the end of 2025. So here we're going to nerd out a little. We've heard a whole bunch about different elevations in Lake Powell, but it helps me to look at a sort of plan diagram of what that really looks like. So you can tell I'm a left brain person because this is my artistic rendering of Glen Canyon Dam. So you have to imagine that you are standing downstream of Glen Canyon Dam, looking up at the face of the dam, and behind that dam is Lake Powell. So Lake Powell is full at 3,700 feet of elevation, and it's empty at 3,370. That's what we call dead pool. It's not really empty. There's still water behind the dam, but you can't get it out because it's lower than the lowest outlets in the face of the dam. We heard Tanya talk about this. The intakes to the hydropower turbines in Glen Canyon Dam are at elevation 3,490. So you go below that, you're not spinning the turbines anymore, you're not generating power. Lake Powell, Glen Canyon Dam is a big revenue generator, about $150 million a year, give or take, supports a lot of stuff. And we don't want that to happen. Also, below that level, at some point, maybe 40 or 50 feet further down, you're not able to push enough water through the outlets in the dam to meet the obligations to the lower basin. It's not because there's not enough water there, but there's not enough pressure behind that water to sort of squeeze it out through the outlet works. It's not enough head. And so that's also a big concern. So again, we don't want water to get there. So the basin states, the upper basin states, and the Department of the Interior set a target elevation of 3,525 as a buffer against getting to critical levels in Lake Powell. And as you heard, we've kind of blown past that target elevation. We're at 3,524 and going down. Now there will be a recovery when the spring runoff hits the lake, but the projections are for Lake Powell to remain below 3,525 for some time in the future. So all that is a prelude to drought response operations, which is basically releases from the upper basin reservoirs that are above Lake Powell, Flaming Gorge, the Blue Mesa unit, and Navajo Reservoir to prop up elevations in Lake Powell. And that happened last summer and fall when there were releases from both Flaming Gorge and Blue Mesa. And as Tanya said, there are plans being worked on right now for further drought response operations this year and into the future. And then there is investigation of demand management. Basically, that would be a paid conservation program that would allow the conserved water to be stored in Lake Powell. The agreement that was reached as part of the DCP allows that storage at no charge, free of the balancing the contents provisions in the 2007 guidelines, which is really important. But it didn't create a demand management program. It just called for exploring the feasibility of one. And each of the Upper Basin states are in some form of process to do that feasibility investigation. Last entry in the Law of the River is the 500+ plan that was just executed last December. It calls for reductions in uses in the lower basin states in the amount of 500,000 acre feet for this year and next year. $200 million, half of which comes from the federal government. It's a significant commitment. And there's some, I think, debate now about how much effect it's going to have. So the Law of the River has evolved, and you can see that evolution here. But nature has as well. And that's the context that we have to consider the rest of this program in. This is kind of a water balance for the basin. And I will tell you up front that there are people in this room who would quibble with every single number that's on this slide. But there's also good backup for them. And this is kind of a generalization. But we've got natural flows of 13 to 13.5 million acre feet. Compare that to the 20 million that they thought they had in 1922. Then we have outflows that consist of uses, evaporation, uses of the tributaries, and the delivery to Mexico. And we've got an imbalance. And again, you can quibble about the numbers, but it's a significant imbalance. We've got more demand than supply. And that may range from about 1.5 million acre feet up to 3.5 million. So if you recall that most recent iteration of the shortage sharing chart, it provides for a maximum of 1.5 million acre feet of reductions. So we're not quite getting there yet. So all these agreements and the current guidelines, minutes with Mexico, they all expire in 2025, 26. Not that far away. But because of the falling reservoir situation, a lot of the focus has shifted from even that not very far away to short-term operations. What are we going to do like now and for the next year or two to try to shore up levels in Lake Powell in particular? We still need, and Tanya referred to this, to address the next iteration of the 2007 guidelines. So significant trends. It is pretty amazing that this basin has been able to voluntarily agree to reductions in deliveries based on hydrology, based on levels in Lake Mead. You're not seeing that happening in other basins. It is something that we need to keep in mind and celebrate. We also have seen an evolution from pretty much zero tribal involvement in these discussions to a much more concerted effort and good faith attempts on the part of the states and the federal agencies to involve the tribes. That is an evolution in progress, but it is a trend. And then I think a recognition of climate change impacts and sort of the limits of what we can do with this river. The challenges, again, climate change, dramatically reduced runoff that we're seeing now and expect to see increase in the future. Tribal water rights, some of which are not yet developed, some of which are not yet settled, and the different values that tribes bring to this river system and incorporating those values into our operational discussions. Access to clean drinking water for tribes is a big issue that has to be addressed in this basin. The Salton Sea is an environmental disaster waiting to happen. It has to be addressed or we will not come to complete agreement in operating guidelines in the future. We have to do all of that without sacrificing the environment. And I also think everybody needs to walk away claiming victory. And that may sound facetious or impossible, but I would suggest that it's essential, because this kind of multi-state negotiated balancing agreement that is going to hurt everybody because we don't have as much supply as we have demand, that's going to get political. And each governor and each manager of a major water district or city or irrigation district, each tribal leader has to be able to explain to their constituency why they're better off with this agreement than without it. And that is going to be challenging in a shrinking river. But I think we need to think about how we can let the different constituencies in this basin have a victory and be able to explain that in a political environment in order to reach a stable agreement. So that's just something to keep in mind over the next day and a half. Thank you.
So thank you very much. And we've had a lot of questions come in. As you mentioned, the guidelines will be renegotiated, but many people have asked about the original compact. As Larry aptly put it, there's a bunch of old white guys up there. We know that everyone in the basin wasn't represented. You know, the term equitable was thrown out, but that concept has changed over time. And so a lot of people are wondering, should we focus some efforts on rewriting the original compact?
So renegotiate the compact. I would say no. I think that the evolution that we just looked at of the law of the river has shown that this basin has been able to address both hydrological conditions and evolving interests as they arise. And if we look at the compact today and ask ourselves, was it equitable given 2022 values? No, it wasn't. But part of the reason I say that I wouldn't suggest a renegotiation is because I don't think it's politically possible. It is just not in the cards if you're the governor of Wyoming to envision being able to sell a compact or renegotiate a compact to your constituents that all the members of the California delegation are going to vote for. And that is just a political reality that we have to take into account, in my view. But I don't think that means you give up at all incorporating those evolved and changed values. I think we can do that. I think that's what's happening right now. But a renegotiation of the compact that would require congressional approval, I don't see it.
All right, and then what about just one more? What progress have the Upper Basin states made toward the investigation of the feasibility of an Upper Basin demand management program under the Upper Basin DCP? What are some of the ideas being discussed at this time?
Well, there are other, I don't know if everybody heard that, but the question is about the progress of the Upper Basin states in investigating the feasibility of demand management. There are other people in the room and I'm sure on the virtual seminar that could answer that better than I. I can tell you what's been done in Colorado. There's been a very extensive investigation of demand management with work groups and listening sessions and sessions with the General Assembly and a lot of technical investigation. And The Upper Colorado River Commission has commissioned a technical investigation of demand management that is ongoing. Each of the states, like I said, has their own process. But I can tell you, it's kind of stalled. And the reason it's stalled, at least I can tell you from Colorado's perspective, is there are a whole bunch of people that are really suspicious of the concept of demand management as having put a target on the backs of agriculture, as having the potential in Colorado, for example, to wipe out irrigated agriculture on the West Slope, and to, in some iterations of this viewpoint, fundamentally change the rural economies within the state that are ag dependent. And those are not unfounded fears. They would have to be dealt with in an equitable demand management program. And it's interesting in that, the alternative could be the curtailment scenario that the Upper Basin Compact calls for, which would also be hugely disruptive and economically detrimental. But people weigh those risks differently. And so, from my personal perspective, I originally was really optimistic about the concept of demand management. You save some water now, you pay people to not use as much water, and you bank it in Lake Powell, and then you can use it if things get bad and you need to ramp up the releases from Glen Canyon Dam. But I haven't seen a majority of support for it in, at least in Colorado. So I don't know what the future will look like there. I think fundamentally we need to solve the math problem somehow. We've got more demand than supply. We have to bring those two numbers together. Demand management would be one way to do it. It may not be the only way. So I think those are the discussions that are going to play out over the next 3 to 4 years.
Well, thank you. If we could give Anne. Again, please continue to put in your questions. There were a lot of scientific ones. We have a science panel later this afternoon, and I'll turn the time over to Daryl, who will start our next session.
Thank you, Heather, and thank you so much, Ann Castle, for that incredible presentation. We're going to move on to the next panel, which is titled First in Time Native Americans in the Colorado River System. And just real quickly before I introduce our panel, initial comments about how we were structuring this conversation and the buildup of the conversations that have been happening this morning. And this hopefully tries to parallel what was happening in the country in 1922 with what was happening in Indian country at the same time, and how that progressed and how that built over the time to current time. And so hopefully you get an understanding of that. And, 12 years ago when I got involved with this work, there's an incredible amount of ignorance in terms of an understanding of tribal tribes and tribal water rights and of the 30 tribal sovereigns in the basin. And there was an incredible amount of ignorance in terms of a capacity divide because of almost 100 years of policy that was already existing before tribes started to get involved in terms of settlement decrees and those kind of things. And we started the conversation at the 10 Tribes Partnership, in 2012, where we really saw, that we needed to do something in terms of how do we bring awareness of tribal water rights and specific tribal situations on their reservations. And you all heard me say a million times, if you know one tribe, you know one tribe. And that was all, calculated in terms of the partnerships efforts at that time to really create an understanding about the tribal sovereigns in the basin. And some of those things that came out of that was the tribal water study that we did jointly with then Assistant Secretary Ann Castle. But, what came out of that was an incredible, and Anne talked a little bit about that in terms of the differing value systems. The partnership made a commitment by developing a vision and a mission statement that said that, in short, that they would lead from a spiritual mandate to make sure the river was always protected for all life and land in the basin. And how were we going to do that? We were going to educate, communicate, and collaborate. And, I think that was the spirit that was engaged in through the tribal water study that has since been built on, with the conversations that we've been able to be a part of with the Water and Tribes Initiative in terms of policy brief number 1, which is the enduring role of tribes in the Colorado River Basin. Again, telling the storyline about, how long we've been in the basin and our commitment to it and the values that we each ascribe to the Colorado River. And so I think this portion of this panel is going to be consisting of Margaret Vick, who represents the Colorado River Indian tribes, my close friend, and I got to have had the privilege of working with her for the last, I don't know how many years, Margaret. And so she's going to lead the conversation off, and then she's going to engage in a conversation with my other close friend, Bidtah Becker, that I've been working for a long time, former natural resource director for Navajo, formerly inside their Justice Department. And now, thanks, California, she works for the state of California now, but in a good way. We started a universal access to, we started through Anne and Bidtah, and they're such champions for, universal access to clean water on Indian reservation. And so she gets to continue that work on a lot broader level, and it's such important work, as we know. And especially in light of, and I'll end with this real quickly so I can get Margaret up here and Jason and Bidtah can chime in. But, and I've given this example, before in terms of testimony that I provided to the House Natural Resource Committee about where my tribe was in 1922. My tribe got moved to our reservation in 1887. We were scattered out on a piece of land west of the Chama Valley in northern New Mexico. The Chama Valley was our original homeland that was taken first by Spanish land grants. So we were put on a piece of acreage where we were subsistence living in 1922. And I think, that's where we were at. And, we didn't even have a town. We relied on the federal government to stay alive while the law of the river was being created. And so, that's the kind of background we hope to provide to you today, just what was going on concurrently and where are we at today. So with that, I'd like to introduce Margaret Vick and bring her up here.
It's a pleasure to be here. I am very humbled, having following 2 professors and 2 assistant secretaries in this symposium. I want to thank Daryl and Matt for inviting me to participate. I also want to thank the numerous tribal leaders that I have worked with over the years who have given me a slight open window into their history and their lives. I'm not going to be presenting any new information, but I am going to be presenting a history that reminds us of what Daryl said, the parallel lives that were being lived during the past 100 years. It was mentioned earlier about equity and environmental justice in the basin. I'm not using those words, but anniversaries permit us to look back and tell a story. This is 100th anniversary, but I'm going to go back about 140 years to start the story that I'm going to tell. And I want to parallel and highlight what was going on in the United States in relation to tribes and tribes in the Western US, not necessarily only those tribes in the basin, and what was going on with the Reclamation Service and the Bureau of Reclamation now in the development of the basin. So first of all, anniversaries of events are not always perceived the same way by everyone. I was reminded of work I did with the Havasupai tribe for many years, and a former late chairman, Wayne Siniela. I asked him if he wanted help with drafting his comments on the 75th anniversary of the establishment of Grand Canyon National Park. He said, "I will do it myself." He wrote a letter declining to participate in an event that celebrated the dispossession of the Havasupai people and the forcible removal from their homes and their gardens. Well, the compact is not one of these dramatic events in our basin history. I do want to highlight that not everybody in the room perceives that 100 years in the same way. So, 1922, Article 7 of the compact: nothing shall be construed as affecting the obligations of the United States to American Indian tribes. We know from two commentaries that were written about this article, Hundley's and Getz from the U of A, that there was very little discussion about this article. And it has been discussed in one case, an ongoing 19-year case of the Navajo Nation versus the United States. In one of the early opinions in that series of cases, the district court in 2014, in response to a Navajo Nation argument that the compact at Article 7 created a specific enforceable trust obligation of the United States. The court said, by its terms, this statement does not create any new or additional obligations of the U.S. to Indian tribes. It merely recognizes the existence of such rights that pre-existed the compact. So we're going to go through an overview of parallel histories, starting in about 1840 and the 1860s in the United States. And the story that I want to tell is that the history of the United States treatment of tribes and Native people and their resources over the past 100 years can contrast very well with a parallel history of development in the basin. Some basic principles of law most people here know. I'm not going to go into them. We know Winter's rights, 1908, the US Supreme Court established that all reservations have implied reserve rights to water sufficient to provide for the purposes for which that reservation was established. And we cannot forget that the United States owns all of the tribal lands, all the reservation resources, including the water rights, and they do hold those in trust for the benefit of the tribes. So let's start in the 1840s. In the 1840s, the Indian population in California is estimated to be between 150 and 300,000 Native people. By 1873, it was documented to be 16,000. We see the 10 tribes of the 10 Tribes Partnership and the dates of establishment of their reservations. These reservations were the result of the forcible removal from the Aboriginal territories of the tribal members, as Daryl mentioned. Hickoryah in 1887, start with Ute Indian tribe in 1861, and then the last reservation established in the basin for Kokopah at the far south end of the basin in 1917. It is not a coincidence that the timing of the Homestead Act coincides with the establishment of the reservations. The public lands came from the Aboriginal territory of the tribes. When they were removed to reservations, that land was open for homesteading. It was opened under the Desert Lands Act. So if we have all of these reservations with winter's rights sufficient to fulfill the purposes of the reservation, let's look at some recent pronouncements of what those purposes were. And I like to refer to the Gila River adjudication and the Arizona Supreme Court's accounting of that in response to requests to document every single purpose for which a reservation might have been established. The Arizona Supreme Court said, despite what may be set forth in official documents, the fact is that Indians were forced onto reservations so that white settlement of the West could occur unimpeded. So where are we today in relation to the tribal water rights? Of the 10 tribes on the mainstream, the 10 tribes of the 10 tribes partnership, 5 lower basin tribes have water rights that were determined in Arizona v. California in 1963. None of those 5 tribes have full development of those rights on their reservations. Only 1 tribe has a court-approved agreement to be paid for forbearance of that use. 4 tribes in the Upper Basin have had varied successes in their settlements. Jicarilla is the only tribe close to full utilization, and all 4 tribes lack infrastructure to put water to use on their reservations. The Navajo Nation has settlements in New Mexico and Utah, which highlights the fact that 3 of the tribes in the basin are overlaid by 3 states, and additional tribes have lands within 2 states, complicating their efforts to quantify and utilize their water rights. The Water and Tribes Initiative report that Darrell referred to indicates that 12 tribes in the basin still have unresolved water rights 114 years after the decision in Winters. So let's look at Article 7. Does the US have an obligation to assert Indian water rights in court? The courts have said no, they don't. And that's, I refer you to the Navajo Nation versus United States Department of Interior line of cases litigating that question. Does the United States have an obligation to participate in settlements of tribal water rights? Again, the answer is no. And I refer you to the 1990 criteria and procedures for the participation of the federal government in negotiation for the settlement of Indian water rights. And there's a whole list of criteria that indicate when the United States will participate in settlements. Oh, and at the end of the presentation, I have a list of references with some links for anybody who wants to take a look at those. So let's go to the time period of the compact, 1922. In 1887, the United States passed legislation commonly referred to as the Dawes Act, which called for the allotment of tribal lands and assimilation of tribal people into the mainstream society. At the time of the negotiation and signing of the Colorado River Compact, tribes and tribal water rights were of little consequence to the discussions because it was the policy of the United States that before very much longer, reservation lands would have been divided up into individual ownership by tribal members, or they would have been sold, or those that went to tribal members oftentimes were lost in tax sales. It was also the policy that the individuals would be assimilated, Native Americans would be assimilated into the mainstream of American society. And this process was accentuated the removal of children, placing them in foster homes and adoption, and banning the speaking of native languages or participating in cultural events. So I put down in the corner a significant event at this time. It was in 1924, during the assimilation time period, that Native Americans finally received citizenship in the United States. The allotment policy resulted in the loss of over 100 million acres of tribal land. What happened in 1934 is the passage of the Indian Reorganization Act. The 1920s were a progressive era in American history. And in 1925, the Secretary of Interior commissioned a study of the problem of Indian administration. Lewis Merriam was hired by the Department of Interior, a known government scholar, a recognized lawyer. He spent 3 years investigating conditions in Indian country in the United States and produced in 1928 an 800-page report to the Secretary and to Congress, commonly known as the Merriam Report. The Merriam Report led to an outrage, a backlash against those conditions, and led to the 1934 Indian Reorganization Act. This piece of legislation recognized tribes as legitimate governmental entities, but only if those tribes adopted constitutions that were approved by the United States. It also ended the allotment period. So during this same time period, we can look over at what's going on with the Reclamation Service and the development in the basin. We have construction of works in the lower basin being completed, including Parker Dam, which created Lake Havasu for Metropolitan Water District's intake facilities. It also flooded the Chemehuevi Reservation. What underlies Lake Havasu is the Chemehuevi Reservation. We also have Headgate Rock Dam construction, not under the Reclamation Act, but under the Rivers and Harbors Act, to supply water to an internment camp that had been placed on the Colorado River Indian Reservation. The reorganization time period was very short, 19 years. The Navajo litigation against the United States has been ongoing for 19 years. And what happened in the 1940s and 1950s is one of the darkest time periods of Indian history in the United States. A policy was enacted through a House concurrent resolution in 1953 for the termination of trust status and tribal status for many of the tribes in the Western United States. By the end of this termination era, over 100 tribes had lost their status as governmental entities in the United States. Their reservation lands had been sold off, and they had lost all federal benefits. The fallout from this time period, as well as the fallout from the allotment time period, plague tribal governments today. We have checkerboard jurisdiction. We have complex issues of status, of access to benefits. So while the United States was canceling, literally canceling tribal status and selling off the land, we have the 1956 Colorado River Storage Project that was passed, and we have the Arizona v. California case proceeding in court. The United States in that case originally filed and prepared claims for 25 tribes in the basin, only 5 of which were adjudicated. So let's spend a little time in 1968. The termination era ended with the enactment of the Indian Civil Rights Act in 1968. But still in 1968, we have the authorization of the Colorado River Basin Project Act. So we have had 20 years almost of a termination era of federal policy. And we know that the Colorado River Basin Project Act had been ongoing for a number of years. So it's almost understandable that this act in 1968 called for the construction of Orem Dam, which would have flooded the entire Fort McDowell Indian Reservation on the east side of Phoenix. It would have also flooded a portion of the Salt River Pima Maricopa Indian Communities Reservation. It was not until 1981 that Orem Dam was taken out as a feature of the Central Arizona Project in Arizona, and that was only after almost 20 years of protest by the members of the Fort McDowell Yavapai Nation. We also have the construction of the Animas La Plata project, which stores water for the Ute Mountain Ute tribe for their domestic use on their reservation. And if you have attended any of these conferences recently, you know that the Ute Mountain Ute tribe still does not have infrastructure to be able to deliver that water to the reservation. So 1968 to the present. The Indian Civil Rights Act, the Indian Self-Determination and Education Assistance Act, Public Law 93-638, which permits tribes to contract with agencies of the federal government to receive money and decide how services to their people on their reservation are going to be provided. We also have reclamation pursuing settlements of Indian water rights on tribe behalves, particularly present in Arizona. Jason's client received a settlement post-1968 and it includes deliveries of the CAP water. So let's pretend that the compact is a living document and say, yes, there are obligations of the United States. Let's see what some of those might be today, looking at some of the most recent developments that Anne talked about. A familiar chart. And the drought contingency plan in Arizona has been, tribes participated, my client participated, Jason's client participated, the Fort McDowell Yavapai Nation made water available under the drought contingency plan. The issue I want to talk about today is that this chart on the left was developed between reclamation and the states. Tribes came into the drought contingency plan after that chart had been developed. So then you look at Arizona and the change in cuts. So this is under the 2007 interim guidelines. We have the ag pool going away down to tier 3. The DCP cuts take it down to complete loss of what is called the NIA priority water. This was all decided pre-participation of tribes. So where do you get, who has the NIA priority supplies? 60% of the NIA water that is being cut under DCP is part of Indian water settlements in the state of Arizona. Jason's client was trying to preserve some of that through the DCP negotiations. So let's take a quick look at the bipartisan infrastructure bill. This is very, very recent. Reclamation projects receive $3.2 billion for work on aging infrastructure. Some tribes do receive their water through reclamation projects and will benefit from that funding. Tribes with settlements and outstanding obligations for infrastructure development share in $2.7 billion funding. But there are 16 tribes in the Western United States that have federal irrigation projects that are operated and managed by the Bureau of Indian Affairs. I mentioned Headgate Rock Dam for Colorado River was not built under the Reclamation Act, but under the Rivers and Harbors Act. 6 Indian irrigation projects in the Colorado River Basin, and there is no funding for aging infrastructure for those projects. They were priority listed projects under the WIN Act. The WIN Act was folded into the Bipartisan Infrastructure Act, and the BIA projects are not included. So I want to shift a little bit to kind of set the stage for the future. So we know that the compact, we saw the 7 white men and Herbert Hoover in the photos earlier. It was negotiated by those representatives of the Basin states. Current activities take place between Reclamation and the governor's representatives of those 7 states. Many of the governors have groups of principals. State authorities, state law authorize those state engineers, boards, districts, agencies, commissions to represent the major water users of the states within their jurisdictions. States and Reclamation negotiated the 2007 interim guidelines, the DCP, the 500+ plan, and are working on the drought response operations plan. And there is tribal participation in the Upper Basin on the drought. Reclamation also has a process to coordinate with the IBWC and Mexico and negotiations that includes a working group of state representatives. What is the institutional mechanism for tribal participation? We see that the institutional mechanism has existed for 100 years between Reclamation and the states. But as we have heard, we are just starting to explore what that institutional mechanism might be. I almost left this slide blank, but the United States owns 25% to 30% of the water in the basin on behalf of tribes. We need to figure this out. This is at the heart of the issue of the basin being able to move forward. There is not water available for the people who live on the reservations, but Reclamation has made water available for 40 million people in the basin. So a few closing remarks. Yeah, this is a silly comment, but this map is the official Reclamation map of the basin. I have tried for the last 2 years to find somebody at Reclamation who could make a map that includes the reservations. But this is the one we have today. For the past 5 years, conferences such as this, and in one-on-one conversations I have been suggesting to regional directors, deputy commissioners, and commissioners that Reclamation as an agency needs a structure. They need somebody. They need a deputy regional director. They need somebody whose job it is to know tribal water rights, to understand tribal water rights, to be in the room when decisions are made, the same way they have someone who knows the interests of Mexico. So that when you say we're going to cut 192,000 acre feet for DCP out of CAP supplies, somebody stands up and says, hey, that's tribal water that's being cut. And there's a recognition of that in the room. We also have to have a process for tribes to speak for themselves and to participate at absolutely every level at which decisions are made. Tribes, if they are not included in that decision-making process, we cannot address the future of climate change unless everyone is incorporated. So I'm going to end there.
Yeah, I think we're going to go to Bidtah at this time.
Hi, Daryl and everybody. Everybody attending virtually as well as I am. It's really, really wonderful to be here with you all and to see a few of you, even if it's just virtual. As Daryl mentioned, after nearly 20 years, I am no longer working for the Navajo Nation. I'm now with the California Environmental Protection Agency as the Deputy Secretary for Environmental Justice, Tribal Affairs, and Border Relations. Yes, it is a mouthful, but I think if, Margaret's kind of closing comments showed why that portfolio exists: environmental justice, tribal affairs, and border relations. And trust me, no one is more surprised than I am that I'm not with Navajo right now. The comments I'm offering today are my own and do not reflect the policies or positions of the agency or the state of California. That being said, I do want to share with you how I started my day. California has created a Truth and Reconciliation Council to seek truth and reconciliation among the Indigenous people of California and the state government. And that's how I started my day, at a council session. And so I want to share two things I heard this morning that I think help frame my comments. The first thing is that 173 years ago, the very first governor of California, and I'm making that face because it would probably be the American version of California, not the Mexican version of California, announced in his inaugural address that California would pay people to hunt down Indian women and children. The second thing that I heard that helps frame my comments was an 86-year-old tribal elder who serves on the council, who shared that she doesn't like to use the word genocide because she is a child of World War II. And when she hears genocide, she thinks of gas chambers. And as I said, I offer these because I think they kind of help frame my comments this morning. Last week, Matt, Daryl, and I, Margaret and Jason met to discuss today's panel. And I believe where Jason and I landed is that our comments are going to focus on where we go from here. At least that's where I landed. And I specifically landed on the concept that somebody offered during our session last week, which is that the federal government must be a leader in helping tribes determine what it should focus its energies on. So let me say that again. The federal government must be a leader in helping tribes determine what it should focus its energies on, or what they should focus their energies on. I landed on that because that statement really spoke to me, because I firsthand in my lived experience know how helpful it is when the government works with the tribe to help them to determine where it should focus its energies and resources when addressing a crisis point concerning natural resources. And that lived experience was when Navajo Generating Station was shutting down. We received one very good piece of advice from Reclamation and one very good piece of advice from Bureau of Indian Affairs that led the Navajo team to much more smartly negotiate what we call the extension lease. That extension lease allowed the plant to stay open for a couple years rather than shut down immediately. And it provided the Navajo Nation some interesting tools to help with transition. It also dealt with reclamation and many other items that we may not have done if we hadn't received those good 2 pieces of advice. And I think it's fair to say that all negotiators left that lease negotiation and that lease feeling we created a very creative and useful product for the Navajo Nation that did not leave the Navajo Nation high and dry, pun intended. But the proof for me really came in the Navajo Nation Council's vote. We had received more yeses on the Navajo Nation extension lease for a Navajo generating station than we had for the original lease extension that had been approved 3 or 4 years earlier. So again, really encouraging as we move forward our federal friends and family to be a leader in helping tribes determine what they should be focused on when dealing with the drought we live in, the future of the basin, the renegotiation of the guidelines. And I want to end, as hopefully people are contemplating that, with 3 concepts. One is that concept doesn't necessarily apply only to the federal government. The second is implicit bias. Implicit bias, for those who don't know that concept, it's that we as human beings have biases means, so here, I'm going to just read the definition for you. We have a bias when rather than being neutral, we have a preference or aversion to a person or group of people. And the key concept is implicit bias. When we have an attitude towards people or associate stereotypes with them, with or without our conscious knowledge. And you can look it up. There's tons of training and there's tons of tests you can take to determine if you have any of these biases. But I encourage you to think about that as you're thinking about the future, either or both on an individual level or as an organization. Government is otherwise. And then the third concept is World War II. If I had done Margaret's project timeline, I would have included World War II in the presentation because I think it helps inform why the federal government was taking some of the actions it was taking in the 1950s. I've said this publicly a few times, some of you might remember, but living on the Navajo Nation is a daily reminder of World War II and the big growth and the new world order that came out of World War II. And I say this because you were either confronted with the challenge of the abandoned uranium mines that were uranium mined for the Cold War. You were confronted with the large coal-fired power plants that were developed to build the West, not Navajo, but to build the West. Or you were just cheering on our code talkers, our Navajo code talkers who we're so proud of. Today, there are many more people who are thinking about that World War II era. And we heard from our 86-year-old tribal elder today who has that front of mind in her life as well. And we're thinking about that, right, because of Russia's actions against Ukraine. So I'll just wrap up. I know I've gone a little bit over time, but just, we live in an equity moment that I think could be an equity historical period, but it'll only become a historical period if all of us participating today make equity part of how we live our daily lives and approach our work. So thanks, and I look forward to hearing from Jason and Margaret. Wonderful comments.
So I think I'm the last person between you and lunch, and so I won't blather on too long. I think Margaret provided some important context, as did Bidtah. My remarks this morning are really focused on the current or the recent and future role of tribes and drilling down on basin-wide decision making. And before I do that, I want to provide a caveat similar to Bidtah's. These are my opinions, not necessarily the opinions of my client. I represent the Gila River Indian community, and they really come from my perspective, having been involved in development of the Lower Basin DCP and implementing that within the state of Arizona and tribal involvement, and also more recently in the 500 plus plan. and more recently, my observations in conversations with other basin tribes and the recent discussions regarding tribal involvement in the reconsultation of the new guidelines, or the framework, as a lot of tribes like to, the new framework, as a lot of tribes like to refer to it. That said, there are 30 basin tribes with their own policy goals, concerns, individual needs, and I do not pretend to know all of those or speak on behalf of those tribes. They're just my kind of comments in general. So I think starting off there, given the history that Margaret went through, you have 30 separate sovereign governments that, given this history, are largely suspicious of the motives of the United States, state parties, and non-Indian stakeholders. And so how do you, if you're on the other side of the table, how do you deal with that? And I think I want to leave you with one word, it's respect. Respect these governments and include them early on in the policy and decision-making process as we discuss the operational rules of the Colorado River. I do believe we're headed in that direction. And I wanted to emphasize this as a fundamental point. So I think what are tribes' current role really, and how do I want, how should they, or maybe think about ways they could be included going forward? So I think in current involvement of tribes, the most recent involvement was in the Lower Basin DCP and the 500+ plan. Tribal participation in Arizona was really focused on conservation efforts, helping the dropping elevation in Lake Mead. Now, the Lower Basin DCP in Arizona has been touted as an example of tribal inclusion in the Colorado River decision-making, and it is. But, and I'm gonna steal my colleague, he's not here, Don Pongre, some of you know, is a bad lawyer joke. You know, it's like 100 lawyers at the bottom of the ocean. It's a good start, but we have more work to do. So, and I think if you talk to those tribes that are involved in it, Gila River, Crit, Fort McDowell, and Tohono Nation, you know, their involvement, they know they were involved or invited to be involved because they had water to contribute for conservation efforts. Had they not, they wouldn't really be part of the conversation. So, you know, I think, how do we include other tribes that also have interest in the basin? And that's one of the challenges we have to deal with. I think, as Margaret indicated, the Lower Colorado Basin Development, Lower Basin Drought Contingency Plan. I'm mixing up I'm thinking of a basin fund issue that's totally unrelated to this. The Lower Basin Development or Drought Contingency Plan was developed by the Lower Basin states in coordination with the United States without any tribal input. And the impact to the community, Margaret showed that slide of the impact to the NIA supplies in the CAP system. Well, the community's entitlement is 120,000 200 acre feet, I believe, or 600 acre feet. And so it had a lot at stake, at risk of curtailment, had DCP gone through without its involvement. So as you can imagine, it was not very happy when it initially heard about this plan for these additional cuts, because it was going to take a direct cut. Now, I think the community also recognized that, you know, the risk to its supply and to the larger basin was such that it needed to cooperate and figure out a way to have a plan where it could accept it, both kind of internal politics, the tribal council could accept it, but also in a way that the larger state of Arizona could accept as well. So it became very much involved in the development of the implementation plan. And I have to say that, you know, the relationship with the state of Arizona has been strengthened between the community through this process. And, you know, but for that process, we wouldn't have been able to do the 500+ plan, I think, as fast as we were able to do. So I think it's an example of cooperation, but it's an example of just one tribe that does have quite a bit of water available to make to use for conservation. So more generally, what a tribes want going forward. Again, I don't pretend to know what all the basin tribes want, but I think there's some general principles that I want to leave you with, and hopefully I'll get through them fairly quickly here. think first and foremost, the protection of tribal water rights is paramount. This seems obvious, but it bears reminding. I think there are tribes, a lot of tribes that whether it's a court decreed right or a tribal or congressionally approved tribal water settlement, they're still very concerned about protecting those rights. And I raised that because in the DCP discussions, there were stakeholder groups that considered tribal uses of water less worthy than non-Indian uses of water. I won't name names or anything like that, but that's an attitude that it's out there. And I think as a basin, we should collectively turn our back on such outdated ideas. And it gets to this implicit bias idea that Bidtah mentioned. Second, and I think this is something I really want to kind of focus on, Margaret kind of touched on, is tribes need the data and tools to develop their own risk analysis. I mean, that's a big thing for tribes. They don't really have the tools yet some do, but they need to inform their internal deliberations about how concerned they should be about the external deliberations and how to manage the river. And it's impossible to address that first issue to protect tribal water rights without having this tool where tribes can do this risk analysis. And it's very well may be that with this tool, many tribes will go, look, we're not too concerned about what the operational rules look like because our water rights are senior priority. We're not that concerned, and we don't need to spend a lot of time and effort being involved in these discussions. They could come to that decision on their own accord, but they need the opportunity to do that, not be told they're not at risk, but to come to the determination on their own. I'd also point out that this is really regarding the federal team. There's frustration from tribes with their trustee in reclamation, particularly, reclamation office goes, well, what do you want? And tribes said, well, we've already told you. And so there's this miscommunication of between tribes and reclamation. And I joke quite a bit about this. There needs to be a translation of, you have to speak reclamation-ese. Tribes need to learn that language and learn how to speak to reclamation so they better understand what tribes specifically want. I think the challenge that tribes have, go back to that other point, they don't have the tools yet to make that risk analysis, to really drill down on what they're most concerned about. So as that is developed, and I think it will be developed, tribes can be better informed about what they need to be concerned about, because tribal leaders are very busy. They have a lot of different needs, concerns on their reservation. And the last thing, they just don't have the bandwidth to spend a lot of time on some of these very, very technical issues. They need help from their trustee to help them figure out how to really guide their decision-making and tackling these issues. I think another thing, third, is tribes want to be able to benefit from their underdeveloped and unused water rights. And there really needs to be a conversation about how this could be done in a manner that takes into account the reduced supply within the basin. For some tribes, this means more flexibility of using their water rights on the reservation. For some, it means addressing the water rights claims or funding projects on reservation. For some, it's water marketing or being able to participate in conservation. But I think, as Margaret's presentation makes clear, tribes have had their resources not only taken from them, but there's been systemic barriers to them being able to develop their water rights. And so that has to be addressed somehow to make this basin more equitable when it comes to that history. And I think I'll leave with my final point is that at a fundamental level, tribes want to be part of the solution. They want to be involved and be able to participate in conservation and helping with these tough decisions. Governor Lewis, Stephen Lewis, for the community would often remark about the community's history of having its water taken away and going without, which really resulted in famine at the turn of the century for the community. And so that experience, that history of the communities, he said, we don't want others to go through that, right? There's a moral obligation, I think, from a tribal perspective to make sure that we all kind of, we all benefit, or we should all benefit. So I think that tribal sentiment is they want to be involved, they want to help, and I think they can often come up with different approaches or ways of dealing with these tough issues that maybe the non-Indian community isn't a big focus from the non-Indian community. So with that, I mean, those are my, probably went over 5 minutes, my comments, but thank you very much.
Thank you so much, Margaret, Bidtah, and Jason, for that incredible panel and conversation. And unfortunately, we don't have time to go through questions today, but we will be responsive to the questions that were asked on Slido. So thank you for your participation in that. And before we move on, I'm going to bring up Bob Kiter, and he's going to make an announcement here before we go to lunch. But thank you.
Let me thank our speakers again, both here and virtually. Let me also note that we will try to pick up some of these questions if we can get ourselves back on time with the schedule. We do have lunch waiting in just a moment. And also our speakers here obviously are available for you to catch in between sessions and during breaks. During the past 27 years, I've been had the pleasure of leading the Wallace Stegner Center. It houses a top 10 ranked environmental law program that trains the next generation of attorneys in natural resources and environmental law, and it provides public education for the larger community through our annual events, including this signature symposium, our Young Scholar program, and the Green Bag series that many of you are familiar with. During that time, we've held an annual symposium on a variety of issues, including climate change, energy, public lands, and other topics. It's unique among law schools. The symposium brings together not only attorneys and legal scholars, but also speakers from a variety of different disciplines, including science, humanities, engineering, and other disciplines, as well as people who work in these areas and on these issues, ranging from local, state, tribal, and federal governments to NGO representatives that provide us with the opportunity to take an in-depth multidisciplinary examination of the critical environmental issues of our time. Today, in light of that history, it's my distinct privilege and pleasure to recognize the R. Harold Burton Foundation, the founding and primary donor for the Stegner Center's annual symposium throughout the past 27 years. The Burton Foundation believed in our vision early on of providing education for the larger community beyond the walls of academia, and provided us with funding in 1996 for a symposium on the native home of hope. Our first symposium looked to Wallace Stegner for inspiration, drawing from his famous quote, "One cannot be pessimistic about the West. This is a native home of hope. When it fully learns that cooperation, not rugged individualism, is the quality that most characterizes and preserves it, then it will have achieved itself and outlived its origins. Then it has a chance to create a society to match its scenery." Words that certainly resonate with our topic today. I might note that we still look to Wallace Stegner for inspiration and embrace his conservation ethic, grounded in passion, pragmatism, and community in addressing the environmental and social issues confronting the West. I also recently learned that R. Harold Burton and Wallace Stegner were acquaintances, and that R. Harold Burton was a great admirer of Wallace Stegner's work. Our symposium on Native Home of Hope was so successful that we applied for funding the following year for another symposium. And once again, we received support from the R. Harold Burton Foundation for our second symposium, To Cherish and Renew Restoring Western Ecosystems and Communities. So suddenly, with the foundation's support, we had an annual symposium, and 27 years later, we are continuing this ongoing series of annual symposiums, including additional support now from the Cultural Vision Fund. And we're pleased to be here today to consider the Colorado River Compact, Navigating the Future. I'd like then today to present an award to the R. Harold Burton Foundation. I might note that we had intended to present this award at our 2020 symposium that would honor the Burton Foundation on the 25th anniversary of their support, but the combination of the pandemic and the earthquake caused the cancellation of that event. So I'm glad that we're here today in person and that I'm able to convey our appreciation to the R. Harold Burton Foundation. Steve Morgan, Executive Director of the R. Harold Burton Foundation, would you please come forward? I'm very proud and pleased to present to the R. Harold Burton Foundation this award created by a local artist and potter, Benjamin Bahunin, in honor of the Burton Foundation's role as the founding and primary donor since 1996 for the Stegner Center's annual symposium. Thank you again for all of your support over the years. We look forward to continuing to work with you on into the future. And we're just very pleased to be able to present the R. Harold Burton Foundation with this award today. Thank you, Bob. Thank you very much. Appreciate it. And now I am the only thing standing between you and lunch, and I think it's that time. So we'll try to reconvene at 1:30, and lunch is available out in the foyer.